Shall I proceed, madam? My supreme namaskarams to Honorable Padmanabh Rao Garu and also her daughter Srimati Sailaja Garu, and best wishes to all of you. In the last class, we have had a discussion about chapter 4 of the Indian Constitution of 1950 regarding the Union Judiciary. Today also we will further proceed and continue with the same subject, and probably in the next class we may discuss about the state judiciary. When you talk about the Union Judiciary, it is directly about the Honorable Supreme Court of India and also the judicial system in a way. We know that the Constitution casted upon a duty on the all systems for establishment and constitution of a Supreme Court. Supreme Court consists of a Chief Justice of India and his companion judges. And you know that as per Article 124, it is the President of India by warrant under his seal and under his hand and seal on the recommendation of the National Judicial Appointments Commission referred to in Article 124A, and they shall hold the office until he attains the age of 65 years. Previously, before the Amendment 13/4/2015, it is mentioned that after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose. So originally, there was a system of consultation process. The President of India will appoint the judges of the Supreme Court after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for this purpose. But by an amendment that is called 99th Amendment Act 2014, which has come into effect from 13/4/2015, this National Judicial Appointments Commission, which is mentioned in Article 124A to 124C, this process of appointment of judges through NJAC has come into force. But before that, you know about judges' cases, out of which 3 judges case is very important. In this 3 judges case, what is decided is the Indian judicial collegium system, which appoints judges to the nation's constitutional courts, has got its genesis in and continued basis resting on 3 of its own judgments, which are called collectively known as the 3 judges cases. So, in order to understand regarding the powers of the President of India for appointment of the judges of Supreme Court, and especially the power under Article 124 of the Constitution of India, and with subsequent amendments in 2015, which we discussed about constitution of a NJAC, we have to understand the three judges cases. Three judges cases means three of its own judgments. What are these cases? And why? In the cases, the Supreme Court of India has evolved a system of appointment of judges, ignoring about the direct and clear unequivocal power of the president under Article 124 for recommendation of the, not recommendation, for appointment of judges by his hand and warrant and seal, what not. This system of judicial collegium system, Indian judicial collegium system has evolved. We have to understand three cases and the background of what was happened prior to these three cases. You know about the emergency in which the famous the then political leader and ex-prime minister Indira Gandhi, in order to curtail the powers of the Supreme Court, imposed the emergency and put forward an argument which is initially accepted but subsequently not accepted, that the courts have no power of judicial review and fundamental rights are also cannot be enforced during the regime and period when there is emergency. And subsequently she lost in the election and the Supreme Court held that she is not entitled for continuing as Prime Minister and what not. With this background, let us see what are these three cases. The first case is SP Gupta versus Union of India 1981. It is also known as the Judges Transfer Case. It's known as Judges Transfer Case. Then the second case is Supreme Court Advocates on Record Association versus Union of India 1993. And the third case is in re special reference of 1988. So when you read these three cases, we'll understand that over the course of the three cases, the Honorable Supreme Court of India evolved the principle of judicial independence to mean that no other branch of the state, including the legislature and the executive, would have any say in the appointment of judges. Ultimately, the purport or the effect of these three cases and the decisions in those cases means that let us have judicial independence. That means that no other branch of the state, including the legislature and the executive, would have any say in the appointment of judges. You know, as per Article 124, the Honorable President of India is having power to consult the such of the judges of the Supreme Court and also the High Court, and then appoint the judges of the Supreme Court. But these three cases say why the President of India shall have this power of only consultation with the judges and then appoint as per the whims and fancies of the central government, and felt let the legislature and the executive have no say in the appointment of judges. Then if the President has no power for consultation of the judges of Supreme Court and then High Courts, then what is the method that can be adopted for appointment of judges? The Supreme Court in its decisions has created the collegium system, which has been in use since the judgment in the judgment in the second judge's case was issued in 1993. There is no mention of the collegium either in the original Constitution of India or in successive amendments. So, the process or the system which we are adapted or following, which we have adapted or following, is collegium system. But this collegium system or even the mention of the collegium is not there either in the original Constitution of India or in the successive amendments of the Constitution of India. So purely it is a judge-made law from out of these three judges' cases. This system is evolved by Honorable Supreme Court of India in order to continue with the judicial independence, which means that no other branch of the state, including the legislature and executive. So we have to clearly read and understand that these three judges' cases, out of which the third judge's case of 1988 is not a case, but it is an opinion delivered by the Supreme Court of India responding to a question of law regarding the collegium system raised by the then President of India, K.R. Narayanan, in July 1998 under his constitutional powers. We have had a discussion in the previous class that under Article 143 of the Constitution of India, the President of India, if it appears to him that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, then he can seek for the opinion of the Supreme Court. By exercising that power, the then Honorable President of India, K.R. Narayanan, by quoting the constitutional powers of him, requested to give an opinion on which an opinion is given by the Supreme Court of India, and it is called third judge's case, and it is of 1998. Then in January 2013, a public interest litigation is filed by one non-governmental organization, an NGO, which is named as Suraj India Trust, and it sought to challenge the collegium system of appointment. And the Honorable Supreme Court dismissed the said petition, that public interest litigation petition, holding that the said NGO is not having locus standi. Locus standi means a right to approach the court for any redressal or relief. Whatever may be the outcome of this dismissal of the petition, but an observation of the Honorable Chief Justice of India, the then P. Sadasivam, that in July 9, 2013, he spoke against any attempts to change the collegium system. So, Honorable Supreme Court not only from these three judges' cases evolved the collegium system and continued with it in order to protect the independence of the judiciary, but also dismissed other applications such as public interest litigation petition filed by an NGO, Suraj India, and then even the then Chief Justice of India, P. Sadasivam, in July 2013, had spoken against any attempts to change the collegium system. So keeping all these things in view, on 5th September 2013, the Rajya Sabha passed the Constitution 120th Amendment Bill 2013, which amended Articles 124 Class 2 and 217 Class 1 of the Constitution of India 1950 and establishes the National Judicial Appointments Commission, on whose recommendation the President would appoint judges to higher judiciary. These things we must keep in view in order to understand what is collegium system and how it is functioning, and recently what was happened and what is happening even today, because even today we have heard the Honorable Chief Justice of the Supreme Court, who observed that within no time 90% of the posts of judges in higher judiciary, that is in Supreme Court and High Courts, will be completed. You know, just last month or so, he was appointed as Chief Justice of India. Then within 1 month, by writing a letter, got appointed 9 judges who had taken oath also. Now they are functioning as judges of the Supreme Court. So very fast the appointments of judges is going on, because 2 reasons. One is collegium system is continuing, and this National Judicial Appointments Commission and amendments are dismissed, were held as unconstitutional. Rather, these amendments were struck down by the Supreme Court for being unconstitutional on 16th October 2015. 16th October 2015. Who are the Constitutional Bench of Justices? J.S. Kehar, Madan Lokur, Kurian Joseph and Adarsh Kumar Goel had declared that the 99th Amendment and the NJAC Act unconstitutional. And the 5th judge, that is Justice Chalameswar from Andhra Pradesh, upheld it. Actually, when we read the 3rd judge's case, that is presidential reference, the Honorable Supreme Court had elaborately observed about the modalities of rendering recommendation by a constitutional entity such as Supreme Court, President of India, etc. It observed that it is not at the discretion of the person consulted to render the recommendation, but internal consultations with the peers shall be made in writing, and the recommendation shall be made in accordance with the internal consultations. That means it is not just oral discussions, but the consultation process must go in writing. The internal consultations which are held with the peers shall be made in writing, and the recommendation shall be made in accordance with the international consultations. But this NJAC bill 2014, which was passed in the Lok Sabha on 13th August 2014 and the Rajya Sabha on 14th August 2014, scrapped the collegium system of appointment of judges. The President of India had given his assent to this bill on 31st December 2014, after which the bill has been renamed as the National Judicial Appointments Commission Act 2014. But as I earlier said, on 16th October 2015, by a majority opinion of 4:1 judges, the Honorable Supreme Court struck down the constitutional amendment and the NJSA Act restoring the 2-decade-old collegium system of judges appointing judges in higher judiciary. So, fortunately or unfortunately, we are continuing with the collegium system. The Supreme Court declared that the NJSA is interfering with the autonomy of the judiciary by the executive, which amounts to tampering of the basic structure of the Constitution, where Parliament is not empowered to change the basic structure. Ultimately, we have to understand the judgment of Keswananda Bharati case, where the Supreme Court has held that basic structure of the Constitution cannot be abridged or amended, and the Parliament also has got no power. And so because of this NJAC and its powerful provisions are interfering with the autonomy of the judiciary through the back door by the executive, and it amounts to tampering of the basic structure of the Constitution. And so the Honorable Supreme Court held that they are illegal. So with this, we have to understand certain other things. The Honorable Supreme Court, though, observed that basic structure of the Constitution cannot be changed, but observed and acknowledged that the collegium system of judges appointing judges is lacking transparency and credibility, which would be rectified, improved by the judiciary. So even this judgment, though held that, rather struck down the constitutional amendment and held that NJAC Act is not applicable, and thus restored the 2-decade-old collegiate system of judges appointing judges in higher judiciary. But the Honorable Supreme Court acknowledged that this collegiate system is not having transparency, credibility. So who has to do it? How to get the credibility and transparency? The Honorable Supreme Court has observed that it can be done by the judiciary by rectifying and improving how the things are going on. What has happened? This National Judicial Appeals Commission, which has got a system, but was struck down. So the procedure for selection of the Supreme Court judges as per that is not accepted. Honorable Supreme Court held that two-decade-old collegial system of appointing judges in the higher judiciary is not in accordance with law. This judgment was hailed by the lawyers Prashant Bhushan and Ramjit Malani, who had appeared for the petitioner challenging NJAC, while other jurists, lawyers and activists such as K.K. Venugopal, K.T. Tulasi and Jayaprakash Narayan opposed it. The only one of the 5 judges bench who opposed the majority decision was Justice Chalmesar, who held, this is very important, one of the judge, that is the judge of the Honorable Supreme Court from Andhra Pradesh, namely Justice Chalmesar, he has observed that the proposed composition of the NJAC would not be a constitutional issue, and that it could have acted as a check on wholesome trade-offs within the collegium, and incestuous accommodation between judicial and executive branches. This thing we must keep in mind. The judge has observed that the incorrect accommodations between the judicial and executive branches is there in this collegium system. This NJAC, if continued, should have acted as a check on wholesome trade-offs within the collegium system. But unfortunately, because he is only one person who supported this NJAC, and out of other 4 judges did not agree, the judgment prevailed upon, and as per that judgment, the Honorable Supreme Court subsequently had taken some steps to have the transparency in the collegium system for appointment of judges. On 3rd November 2015, the Supreme Court of India upheld that it is open to bringing greater transparency in the collegium system within the following existing 4 parameters, with opinions from both the parties. That is, the petitioners who challenged the NJAC Act and also the government. So even the Supreme Court found that the collegium system is not properly working. So it wants to bring greater transparency. Then it said that let us have some good thoughts to have transparency, but it must be done within the existing 4 parameters. So it asked the opinions from the petitioners who filed the writs challenging the NJAC Act and also the government. What are those 4 parameters? The first one is how the collegium can be made transparent. So collegium system shall continue, but how the collegium system can be made transparent. So the Honorable Supreme Court has observed that collegium system is not working transparently. So to make it more transparent, it asked opinions. That is first parameter. Second parameter is the fixing of the eligibility criteria for a person to be considered suitable for appointment as a judge. This is the second parameter. In the Article 124, clearly eligibility criteria is mentioned, but still the Supreme Court observed that the second parameter is how to fix the eligibility criteria, rather the fixing of the eligibility criteria for a person to be considered suitable for appointment as a judge. This is the second parameter. The third parameter is a process to receive and deal with complaints against judges without compromising on judicial independence. So it wants to have a system regarding disposal of the receiving and disposal and dealing with the complaints against the judges, but judicial independence shall not be compromised. Then the fourth one is, let us have a debate on whether a separate secretariat is required, and if so, its functioning, composition and powers. In order to avoid delay and also to have transparency, these 4 parameters are kept with in the mind and offered it to all to give opinion. But what has happened on 19th November 2015, the then Attorney General of India, Mukul Rohtagi, informed the Honorable Supreme Court that the central government will not prepare a draft memorandum for judicial appointments contrary to committed earlier and suggested the same to be done through a judgment. So, you know, actually, when the Supreme Court has kept 4 parameters and requested the central government and also the petitioners who filed NJSC writ petition to give their opinions or to give their help to have transparency greater than what is there, the central government has committed that it will give a draft memorandum. But ultimately on 19th November 2015, it is not accepted. The Honorable Supreme Court, Honorable Central Government Advocate, Mr. Mukul Rohtagi, Attorney General, informed that let there be a judgment on all these 4 points and that judgment to be followed. But that judgment, that is no judgment is later on passed. Then what has happened? When there is no further steps taken on these 4 points in order to have greater transparency, the collegium system is followed. Now the point is, when the collegium system as per the 3 judges cases which we have discussed is continuing, definitely because there is lack of transparency both in consultations between the pairs and also otherwise, though these consultations are in writing, lot of doubts cast upon. Then in those circumstances, and what we can think of is these transparency is not there. When